Thank you, Mario, and thank you for the CCD COA as well for giving me this opportunity to moderate this panel. And especially, I'm thankful that they have elevated me to the status of doctor in certain brochures that I am not. So, but let's see, that is a vote of confidence from the CCD COE to me. This hopefully will be a very lively panel in the sense that cyber espionage is something that everybody wants to have a say on, or at least have a thought on or position on. It's almost like the GDPR in the European Union at the moment. Everybody's talking about it, but few people actually know what they're talking about. But thankfully, I have a panel who knows what they're talking about. And it's a well-esteemed panel, and in the sense that we have a certain like a Venn diagram on the stage as well, whereas Lise was closely involved with the writing of the Tallinn manual, and especially on the chapter as well on the rules on cyber espionage. On the other side of the aisle, we have Dr. Lubin, who is showing let's say, a difference of opinion on what is cyber espionage, what are the norms in international law, vice versa, the Tallinn manual. And in the middle of the Venn diagram, we have Ms. Janeke Borgelsen-Carlsen. It's a very difficult name to pronounce, even for an Estonian. But she is a practitioner in the Norwegian Ministry of Defense. And of course, it's very intriguing to speak about cyber espionage in an unclassified setting. But I think you have to accept that we have certain limits of how far we can go with our positions, or even with the practicalities that we can discuss. And this is especially for our practitioner in that sense, that be gentle on her, because she cannot say everything that she knows, but she will give the best answer that she can. And cyber espionage, in a sense, is an intriguing topic as well, that it has been on the agenda for the CCD COE as well for quite a long time. CCD COE has presented even book chapters by Dr. Katrin Tsiolkovsky, for example, on the matter of what are the norms or what they aren't in international law. And last year, there was a very good article in the proceedings of the CCD COE's CyCon conference by Martin Libitsky about cyber espionage and where this thing is actually developing. Are actually now states getting into this position where they are saying that even though espionage might be allowed, are there norms of behavior of what you can do with that material or data or information that you gain from those operations? I advise you to look into that. It gives you a different view of what might be at least not the perfect US position, or what might be actually the US thinking of how this thing could actually evolve in the future. For example, he brings out that even if we look at the OPM hacks, the doxing of the DNC, for example, that these things taken into isolation are quite acceptable state behavior in the world of espionage. But what isn't nowadays, as he posits, is that how you use that information to actually influence different democratic processes, or influence even certain intelligence operations that might go beyond just the intelligence world, but also into the diplomatic and political. So there is quite a lot of topics at hand that we need to discuss today in this panel. And I'll leave this to the panelists to open of how they see the world of cyber espionage. I'm not a fan of the cyber prefix, because usually I think what we are talking today is espionage, plain and simple, just conducted by cyber means. But nevertheless, states have spied on each other for as long as the history goes. And most probably since when the civilization ends on planet Earth and maybe continues on Mars, it will continue as well. But to set us off what we're actually talking about and what is the Tallinn manual position on this, I would give now the floor to Ms. Liis Vihul to help us out of what the Tallinn manual sees and what was the process behind it and how we actually got to those rules that we see in the manual.
Right, thank you, Erki. It's a pleasure for me to be here, so thank you to the CCD COE for inviting me back to speak at CyCon. I actually spent 9 years working at the Law and Policy Branch at the NATO CCD COE. I've been gone for a year, but it's really an honor and privilege to continue to be affiliated with them as one of their so-called ambassadors. But indeed, I was actually a member of a 20-person group that also took the liberty to opine something on cyber espionage. And I hope that our group at least knew what we were talking about. So there's actually a story behind how the cyber espionage rule ended up in the Tallinn manual. Those of you who are lawyers, if you've looked at the Tallinn manual, then when you flip through the table of contents, you'll see that it's set up like a classic international law textbook. It starts with sovereignty, goes into jurisdiction, talks about state responsibility, then all the specialized fields of international law, human rights, space law, law of the sea, you name it. But then there is one kind of an odd chapter that's titled Responses Not Per Se Regulated Under International Law. And there are two rules there. The first is on cyber espionage, and then the second is on responses to hostile cyber activity by non-state actors. And even placement of the cyber espionage rule into that section tells you how we thought about cyber espionage, which is that international law does not per se regulate espionage, and thus it does not per se regulate cyber espionage. And what that means is that when you look into the corpus of international law, when you look through different treaties, and when you assess the customary nature of international rules, then you don't find one in neither that says espionage is unlawful, that it is prohibited for states to engage in espionage, nor is there one rule that says cyber espionage is unlawful for states to engage in. So that's what this black letter rule means. Cyber espionage, not per se regulated, means that international law does not specifically address the issue of espionage. But then we have quite a lengthy commentary to this black letter rule, to this bold statement, where we then go through scenarios where even though a state might be engaging in espionage, it is not violating a prohibition of espionage because we concluded that such a thing does not exist, but nevertheless the state may be in breach of international law. It may be in breach of some other rules of international law. And then we bring various examples. For instance, when a state engages in a cyber espionage operation, but that cyber espionage operation has got unintended consequences. So something goes wrong, and let's say those unintended consequences are quite severe. They result in physical damage to the target cyber infrastructure. Then we said that the state has not violated international law because it has breached the prohibition of cyber espionage, because again, that does not exist, but rather the state has violated either the sovereignty of the target state, which protects territorial integrity, or perhaps the state has engaged in an unlawful use of force vis-à-vis the target state. And then we brought other examples from other areas of international law. We said that if a state engages in cyber espionage vis-à-vis diplomatic communications, that act too is prohibited, is unlawful, again, not because there is a prohibition of espionage, but rather because diplomatic communications are inviolable pursuant to diplomatic law, and therefore when a state engages in cyber espionage against diplomatic communications, it has violated that rule of international law. So this is how we approach the issue of cyber espionage in the Tallinn manual. And what do I mean by we? It was a group of 20 scholars. We came from different parts of the world. There were scholars and practitioners from Europe, from North America, somebody from Africa. We had a Japanese scholar, a Chinese scholar, a Belarusian scholar. So it was quite an international group. And all 20 of us, again, agreed with the black letter statement. International law does not per se outlaw cyber espionage. However, there may be situations in which espionage violates other rules. And then, of course, when it came to those other rules, then sometimes we also differed in our legal analysis.
Well, that's the setting of the Tallinn manual. But the funny thing was that when I was preparing for this panel, I actually read about, let's say, 300 to 400 pages on cyber espionage and different legal aspects of it. And I came up out of it very frustrated in the sense that you have schools of thought that say that it is something that exists either extra legally or as a lex specialis, that states at least understand that we spy against each other. So it's not a violation of the law, but it's more of a, let's say, a lower level breach in that sense, that they tolerate it. And in that sense, the Tallinn manual, I think it's right on the existing law as it stands, but I think there's also certain developments that, as I looked to the commentary as well, that it wasn't as clear-cut in the sentiments, that there were differences of opinion amongst the scholars themselves as well.
Well, that actually characterizes the entire Tallinn manual. If you put 20 lawyers in a room, they're bound to fight, and sometimes those fights were very extended, and very seldom there were also a little bit hurt feelings, but we finished the project as good friends. But that is true. Your takeaway is correct. Actually, the interesting part about writing that particular commentary was that even though we did not want to do it, we had to assess the lawfulness under international law, not only of cyber espionage, but also classic espionage. We could not treat cyber espionage without looking into the situations where states spy on other states by sending their agents into the territory of other states. And there, actually, when we looked at that particular situation, we did cyberize the situation. So when we've got one state's organ going into another state and doing a close access cyber operation, cyber espionage operation, then the outcome there was that the majority of us said that that action too is unlawful under international law because it violates the territorial integrity of the target state. And I believe many people, when they read that statement, it sort of catches them off guard. You didn't say that cyber espionage is unlawful, right? And in most cases, we actually concluded that it is not unlawful because it does not breach territoriality the way analog espionage operations do, but because we were dragged into this classic espionage scenario, we knew that the manual would be incomplete if we didn't address that particular scenario, and that's how we were split. The majority of us said that yes, those close access cyber espionage operations, which also means that all other espionage operations outside the cyber context, when they occur on the territory of another state, are unlawful under international law. There were a couple of us who said, well, when you look at the principle of sovereignty, which is what we're talking about, then that principle developed in international law, taking into account the fact that states have always engaged in spying on other states' territory, and therefore there's an inherent exception in the principle of sovereignty that permits other states to operate in your territory when they're engaging in spying. So we were split. In our particular 20-person group, it was the majority versus a couple of other experts. Had it been a different group, maybe we would have been equally split. But we did acknowledge the two ways in which you can assess the lawfulness of cyber espionage, and thus also sometimes analog espionage under international law.
Could you provide me the names who actually didn't agree? Joke.
Will you hire them?
I'll see. But the thing is that I think what has happened with the cyber means, in the sense, is that we have much more availability to gather data and information, and that has changed, of course, with more digitalization of our way of life as well. Because previously, maybe the states didn't actually understood. Let's say they had this predictability on the matter of how much they could be spied upon. But now this has actually also gone much more broader and much more general, and that also makes states more vulnerable. And by just looking into materials, there are a couple of arguments as well in the literature that say that spying, and it's a counterintuitive argument, I would agree, that spying actually enhances stability and predictability in international relations. Because you know more about your opponent or your adversary or even your friend, unfortunately. And this gives much more transparency and predictability of how they would behave. And you would assume that they would also know about you. So there is this argument as well. But in the sense, I think what the Tallinn manual gives you is that even the legal expertise and the experts are not divided, but they have difference of opinion, and that's fine in a legal and a scientific debate as well. But on the policy side, I'd say that states are much more pragmatic in that sense that they do not let too much law constrain themselves when they do those operations, but they do want to be in the right. They do want to be on the right side of the law when something happens or when their operations are being discovered, of course. And I think this would be now a good time to go into this practitioner's view of what actually states do in this sphere, how the states see the law, at least from their own operations aspects. And maybe Janneke, you could give us a brief on that.
I will, and I hate speaking when I'm sitting down, so I'm going to be using the podium. Good afternoon, ladies and gentlemen. I am Janneke Karlsen, and I'm from the Norwegian MOD. And as Erkki said, I do have to start off by saying I speak today only on behalf of myself. I do not speak on behalf of my Norwegian Ministry of Defense or the Norwegian government. However, I am a practitioner. This is my current day job. And if I don't watch myself, I will be out of a day job. And my MOD was, it was kind of a stretch for me to come here on this topic. So I ask for your understanding that there are some discussions I will have some limitations on. I'm pretty sure you understand this. Let's see. Okay, so I'm going to be starting off by actually doing the hot wash-up of my presentation. These are my main points of today. And you will see, first off, I do not use the term cyber espionage. I use the term espionage, and there's a good reason for this. In my view, if we are to assess cyber espionage and its relationship with international law, we have to address espionage in all domains. We have to look at espionage as the distinct creature it is in the global order from a historic view and as a premise for global stability. So this is why I throughout my presentation is going to use espionage, and I warn you, I'm going to be saying intelligence sometimes as well, because that is the normal term I use, but I use espionage because this is, the term used at this panel. Okay, Tallinn Manual. I'm a lawyer. I love rules. I love legal framework. This is why I studied law. I like law and order. If you ask my kids, they will tell you I'm a big fan of rules. And I like the Tallinn Manual. I think actually, and you can see I use this a lot in my job. And I just told Liz that, I've been starting to taping the pages together. I think this is a really, really important and potentially norm-enabling tool for practitioners as me, for the policymakers, for governments, and also for academics. So that's the first off. I really like the Tallinn Manual. And why I like this so much is because, cyberspace, we have all come to depend on, a functioning cyberspace. And still, cyber is really technical. It's really hard to grasp if you're not a technician. Trust me, policymakers are not technicians, so we lack precision. The policymakers lack precision. We lack precision when it comes to definitions. We lack precision when it comes to, dividing responsibility, and we lack precision when it comes to the application of international law in particular. So this is where manuals like this are really helpful. And I also just want to add a really short comment, because there's an upcoming Oslo manual as well, which deals with certain topics, a document similar like the Tallinn manual by experts on specific topics in the law of armed conflict, some of them relating to the cyber domain. So, in lack of other, cyber documents, these are really, really important. So just to start off by that. And then, I am sorry, Liz, but it's my view that the Tallinn Manual fails to describe lex lata when it comes to espionage. I think if you read not the rule itself, the general rule is, it's excellent. We have the rule out there in black and white. But the commentaries when it comes to espionage, I think it doesn't reflect state practice, widespread, long-standing state practice. So when you have part of the manual, which is kind of being seen as irrelevant by the policymakers, it might also affect the manual as a whole. That's an unfortunate side effect, because they're not in sync with state practice. There is no state that would ever consider, terminating espionage due to, the commentaries in the Tallinn manual. An example is what the manual says on diplomatic and consular law. Would actually just plainly state that conducting espionage from a diplomatic premises is a violation of international law, period. And people, it must be the least kept secret to us and to all of you that diplomatic premises are being used in this way. Receiving state spy on embassies and sending state spies from their embassies. So, there's it's a controversy there. So unfortunately, I think that I would rather have seen the espionage chapter taken out. So if the legal expert minds, which they are, did not succeed in describing Lex Lata, what does this mean? Legal anarchy? No rules at all? Lawless Wild West for the intelligence services? Absolutely no. And all of this is probably very unsatisfying for the open source community. I will still hold that states' espionage business is subject to a large set of rules of the game, if you will. And I have listed some of them here, and I'm going to be careful not to use too much time. National laws are important. International obligations are reflected in international laws. The trend is going towards national laws on foreign intelligence to become much more detailed. I'm going to use Norway as an example. We are currently revising our Foreign Intelligence Act, and it's going to go from 7 paragraphs to 90. That tells you it's going to be have some clarity added to it. And then you will have doctrines and manuals, especially if your intelligence services are part of the armed forces, because in the military we love manuals. These will, of course, often be classified, and the more detailed they are, the more classified they are. Still, they're there, and they're regulating the espionage conduct of states. And intelligence community do work together. There are agreements between states. These are always classified, but they still put limitations on behavior. Because states' international obligations are reflected into limitations on how they conduct intelligence business. And then there's the kingpin, that's state practice. Because what is international law if it is not the will of states? And even though espionage may not become customary law, because you will have a problem having that official opinio juris, it is still widespread, long-standing, consistent state practice. Some of this might be seen in the open, and some of it is just seen from us on the inside. But you will see it from states' tolerance of certain intelligence acts, the diplomatic, use of diplomatic premises being one of them. Of course, you will see an outcry if you actually manage to catch a spy. But nevertheless, we presume people spy on us. I'm sure they presume we spy on them. Everybody does this. It's state practice. And we tolerate it. We don't accept it. You will never hear anybody saying this is lawful, but it's tolerated. And you will also see this by the lack of sanctions. If, in fact, espionage acts are a violation of international law, you will have available legal sanctions in form of countermeasures and stuff. It's not being used. In the intelligence world, it's more a use of a tit-for-tat game. You expel one diplomat, I expel one of yours, and it has its own kind of sanction regime. But it's not legal sanctions as you would see if they were in fact considered breaches of international law. And then, of course, you will have national and international courts, especially when it comes to the right of individuals, right to privacy. We see a lot of ongoing cases concerning the balance of national security and what the intelligence services can do versus, how much can we infringe on the right to privacy. And I predict that, in the long term, this will put concrete legal limitations on how states conduct their espionage. So if you have all these rules, what is the gain by putting them into like a conventional legal framework and try to put it down into written words? I have to be honest, I'm not sure it's possible. I'm not sure it's worth the time we spent on it. But should we try to do so, I strongly feel that we need to start by putting our feet, and look at the creature, the elephant, if you will. What is espionage? We have to try to define what is espionage. And I use this wonderful tool called Google, and I found some of these definitions online. And I'm guessing this is a room full of really smart people, so you will see it's about obtaining information, collecting information, reporting and collecting information. And also the manual itself has a similar type of definition, but it's on gathering information. So common factor here, people being information gathering. And this is what separates espionage in the international world from other type of operations that states conduct with an effect on other states. It's the purpose. It's for information gathering purposes. It is not to cause harm. It is not intended to cause, major effects, physical damage, to influence, elections, the outcome of elections, the domain reservé, which is used in the manual. It is for information gathering purposes. That is, if you can try to put that into clear definition, we would be a long step ahead. And of course, it's never that easy, because on the lower scale of the effect, there will be some blurry edges. It's sophistication of the techniques available allows us to actually protect ourselves, states, from other states' espionage in form of active defense measures. You can have like hackback operations, stealback operations, which will be on the low end of the scale, but still will have an effect. And I'm not able to tell you, where those lines go, but this is where it's a little bit blurry. So if we have defined, what is espionage, then the next step would be how to, go forward from there. And I strongly feel that we have to address, as I said, espionage, including cyber espionage, of course, from the core of espionage and its place in the international relationship. It is a fundamental premise for two other fundamentals in international law. States' knowledge of other states' intentions and capabilities is absolutely necessary for us to keep, the world a little bit more stable. And that is because, one, it's related to states' right to safeguard existence and sovereignty, and two, also, it's related to states' duty to refrain from intervening in other states' relations. And in order to do that, you have to have information. So I see espionage is not contradictory to the principle of sovereignty or non-intervention. It's actually supporting of it. So this is, from where I would start. And then, of course, this is not a carte blanche for states to, do whatever you please as long as it's for information gathering purposes. Of course not. You have specific legal regimes, in particular concerning the rights of individuals, where you have to go in and concretely assess how far can we go in our espionage operations before it's violating international law. And that's where I'm very much in line with the expert group and the Tallinn manual. In particular, again, this is most clear and most current when it comes to the rights of individuals and the right to privacy. And I also will just finish off by, referring to the European Court of Human Rights, Article 8, which is, the article on the right to privacy. It explicitly refers to an exception when it comes to national security. And that's where we need to find the balance on the political side, on an ethical side, and on the legal side. Thank you.
Thank you, Annika. I think there are many good takeaways on that, and especially how the field is developing. In the sense, like you mentioned, constraints from domestic law, they vary from nation to nation, in the sense, and you cannot just compare one state's, let's say, intelligence apparatus to another one's, and what the constraints are in the political system, for example, and the checks and the balances. And at the same time, if you look at even in Europe or even across the transatlantic space in the Organization of American States, there is now much more focus on the human rights and how far can you actually go in intelligence operations as well if you want to violate somebody's privacy without a court order. And the thing is, the balancing question is that, well, you might now have the access with the means, but should you do it? So there are quite a lot of let's say, existential issues for states of how they provide national security, but as well as how do they keep their human rights obligations in check as well. But with the lex specialis, it's an interesting topic in the sense that since it's a special law upon the general law, then of course it's hard to, let's say, find the explicit place where this is written down. So it seems like nations have accepted that it is a customary law norm. But at the same time, no state wants to be really explicit about this norm as well. You don't find the states really showing opinion juris as well in a very, let's say, in international tribunals or international judgments. But maybe this is something that Asaf can kind of show light upon, because I know that he has an idea of how this lex specialis, or at least how the cyber espionage might have more norms than we see in the Thailand manual, or how we perceive the field as such. So Asaf, please.
Thank you. I want to thank the organizers for inviting me to speak. My critique is not about Thailand Manual 2.0. My critique is far broader, and it's about the way the Invisible College of International Lawyers treats this field. And I'll give you one example. I worked for Israeli intelligence for about 5 years, and I then went and did my first degree in law and international relations at Hebrew University of Jerusalem. I took a course, one of the first courses I took, on public international law. It was taught by Yuval Shani and Moshe Hirsch. And one of the first things I did was to open the syllabus and to search for the week that we will talk about espionage. Because it seemed to me that if there's a week about outer space law, and a week about the law of the sea, and a week about use of force, there should be a week about spying. It's an equally fundamental part of state practice. And yet, as you all know, I was naive. There is no such sessions. In fact, I, in my research, looked at 100 syllabuses of syllabi of public international law. Not a single one of them introduced international law, espionage. You'll be happy to know that a lot of them are now introducing cyber as a field, but no one is introducing espionage. And so what we're having is a blind spot within our international legal thinking about this space. And to give you one other example of this blind spot, since 1945, since the UN Charter was adopted, there's been 3 books ever written about the topic of espionage and international law. That's it, 3. Now, it's not really true, because the first book is not even a book. It's a compilation of articles produced in pressure by the American Society of International Law in the wake of the U-2 spy plane incidents in 1962. And the last book is a doctoral dissertation that was published in the original French and never been translated into English. And the middle one is a manuscript produced by John Kish in 1995, and he died before he could complete it. So the university asked David Tern to come in and take his place, and he says in the introduction, listen, I didn't know it was all scribbles, so I did my best. I hope it works. That's what we have produced, the Invisible College, about espionage and international law, okay? There's been, at most, since 1945, 100 articles, academic articles, ever written on this topic. Just to compare, law of the sea, use of force, outer space law, thousands of legal pages have been written. That's all that we were able to produce. Another example, I did a Google Trends this morning. consistently, every field of international law receives some general interest in searches. Okay, from outer space law to the law of the sea, the laws of war. The values on the left, the average value is about 7 or 8. It's a value point that Google has. Espionage law is always on 0. Okay, never searched, never of interest. And you might say to me, oh, that's obvious. It's obvious because there is no espionage law. There is no lex specialis of espionage. In fact, when submitting my paper to this conference, all 3 commentators, anonymous commentators, said to me, prove to me that there's a lex specialis of international law and espionage. And what they were saying was they were echoing the dogma that exists in our community. And the dogma was best articulated by this man. He's former assistant general counsel to the CIA. His name is Professor Radson. And he said that mortals should not attempt to perform miracles, right? That we should not convert water into wine. That is to say that we should not reject our perpetual drive to find unity in disorder, accept that espionage is beyond the law, and move to other projects with grace. So I gracefully declined the invitation. I want to propose to you that there's a different way of thinking about this whole space. The next 2 slides were about Tallinn Manual, but I think the presentation you already heard until now gives you a sense of where this space is. That is to say, I'll say one more thing about this, because the title of the presentation is Cyber Law and Espionage Law as Communicating Vessels. And it's really important you understand that, in my view, any attempt to compartmentalize one without addressing the other is a flawed pursuit. That is to say that every low-intensity cyber operation that is below the threshold, in Michael Schmidt's terms, below the threshold cyber operations, those that do not reach the level of a use of force, inherently echo the same type of traditional espionage operations because they're similar. That is to say that the same actors instigate them, intelligence communities. So think of a DDoS attack against a governmental agency and compare it to a traditional spy going to that governmental agency to steal a document. In both those cases, you'll have the same actor instigating it, an intelligence agency or their proxies, against the same actor, an intelligence agency or a governmental agency or their proxies, using the same technologies, cyber-enabled tools, and today even the most basic intelligence gathering operations involve some component of cyber. From OSINT, we used to open a newspaper. Now everything's online. To UMINT, the most traditional form of espionage, now has cyber enablements. We have to use cyber. It's called cyber human now. Okay, we have to use cyber in one form or another, even in the most basic forms of intelligence gathering. Both of them involve some accountability thwarting, some form of plausible deniability. Both of them involve the same potential international law violations. Both of them will trigger sovereignty, non-intervention, diplomatic immunities. Both of them are part of a broader informational environment, the informational warfare. Dr. Libicki spoke about this here, wrote about it sufficiently. The only difference is the goals, as was presented by the previous speaker. One is about collecting intelligence passively, information passively, and the other does something else to the information. But besides that, everything is the same. So any attempt to add law to one space will automatically result in tidal waves that will engulf the other space. This is the law of communication. I'm sure you've done this in elementary school or middle school, this experiment where you put So any attempt to create laws on sovereignty in cyberspace in the context of traditional low-intensity cyber operations will have immediate effects of espionage. And that is why Tallinn Manual was right, was saying we have to address this. But what they did was to compartmentalize it. That is to say, we're not going to talk about the lex specialis. We don't really want to get into the nitty-gritty of what the state practice and opinions of espionage really is. So we're just going to call it not per se regulated, or in Radsan's terms, we're just going to say it's an extra legal construct. It's not part of what the law is ambiguous on this, and rush to specific activities. And the result is, for example, in the sovereignty context, saying that if you engage in an espionage operation, be it cyber or otherwise, you violate sovereignty. And every close encounter espionage, which are some of the most foundational espionage operations, involve entering the sovereignty of a foreign state. The most basic ones, going back to Italian Renaissance, certainly going back to the religious war that brought us the Westphalian world order, all involve these kinds of espionage operations. None of this is mentioned in Tallinn Manual 2.0. And it's not surprising, therefore, that the UK Attorney General, in his statement last week, said, I disagree. I don't like the idea that the principle of sovereignty should apply in the same way to cyberspace. Without saying why, obviously the reason why is because that will be pretty detrimental to what we think about in our activities in cyber surveillance and cyber espionage. So I want to propose to you a completely different framework. I'll end with this on how to think about espionage in international law. And it starts here. And this begins with a quote from the European Court of Human Rights in Zakharov v. Russia, one of the most important surveillance cases ever produced by the European Court of Human Rights. It's very long and very dense. But there's a paragraph 233 in that case, where the European Court of Human Rights says that there's 3 stages in which we regulate spying: before, during, and after. Now, if you're an international lawyer sitting in this room, you've already heard this type of a framework, regulating before, during, and after. It's use ad, use in, use post. We're familiar with this. So there's no reason not to conceptualize the same kind of frameworks we have and bring them to this espionage domain. So what this does is that it begins articulating what the use ad explorationem, the use in explorationem, and the use post explorationem might look like. And within this presentation, because I don't have time, I'll just talk about the first one. But where I derive a lot of my constraining principles is from general principles of law, which we can use, as the PCIJ and ICJ afterwards have used, in order to fill certain gaps and provide more clarity to amorphous regulation. So let me just briefly talk about the use ad. There needs to be an understanding that there is a sovereign right to spy. And that sovereign right to spy is not a customary norm, not articulated anywhere. It's a very clear right. It's a derivative right that you cannot perceive of our existing public order without first thinking about it. So let me just give you a few examples. If you believe in anticipatory self-defense as a right that states possess, you must believe that there's a derivative right to engage in intelligence gathering. In peacetime, for how else will a state know that a threat is overwhelming, leaving no choice of means and no moment for deliberation if it doesn't engage in peacetime intelligence gathering against that threat? Even if you don't believe that anticipatory right of self-defense exists, and you're China or Africa, and you believe that all that binds us is Article 51 of the UN Charter, you still must believe that there's a derivative right of intelligence gathering in peacetime, for how else will you be able to show the UN Security Council that the threat is overwhelming, leaving no choice of means to get a UN Security Council authorization to use force if you don't engage in peacetime intelligence gathering? Think of IHL. We assume that if the United States attacks North Korea tomorrow, then they, from moment zero, should be able to engage in discriminate and proportionate attacks. Now, how will the United States be able to engage from moment zero during the armed conflict in proportionate and discriminate attacks if it did not engage in peacetime intelligence gathering, creating a target bank against those targets? So again, our international legal order assumes that we engage in a derivative intelligence gathering in peacetime. And I have a lot more sources, and I spent my entire doctoral dissertation talking about all of them. Within the limits of this, I'll be taking this up in Q&A, or afterwards I'll be happy to talk about each and every one of them. But one of the most important things, in 2016, in this conference, Dr. Russell Buchan came in and said, there can be no customary right to spy. And he said 2 reasons for this. The first was that secret law doesn't create law. The secret practice doesn't create law. And I'll take this up later if you want me to. But the second point, the more cited point, is that state practice and opinion jurists are going in opposite directions. Everyone spies, but everyone bans spying domestically. And therefore, state practice is going this way, opinion jurists is going this way. This has been cited so many times. And this is flawed, because what we need to start thinking about is spying as an Offeldian liberty right. And I'm sorry that I'm bringing back Hoffold. For those of you who have taken jurisprudence a long time ago, Hoffold was a legal philosopher, and he distinguished between claim rights and liberty rights, between hard rights and privileges. A hard right is a hard that creates an obligation on a third party to allow you to enjoy your right, whereas a liberty is a right that doesn't put any obligation on a third party. The right to spy is a weaker right. It's a liberty right. In other words, I'm saying that in the way we think about Lotus needs to change. Lotus said that everything that is not prohibited is permitted. We need to understand Lotus as meaning, as the criticisms have shown, that everything that is not prohibited is a privilege. Everything that is not prohibited is a liberty. What a liberty means is that, yes, I'm allowed to spy on you, but if you capture me, if you catch me, you have a right to use whatever enforcement mechanisms you have in your possessions to try to prevent me from spying on you. And that's not a problem. So when state practice and so when countries domestically prohibit spying, they are recognizing the right to spy as a customary liberty right, not saying that the right to spy is not part of the law, is outside of the law, and so on and so forth. My final slide is just this. If you accept everything I said until now, you recognize that there's a right to spy under international law, and you recognize that that it's a liberty right, a privilege. What comes next is the principle or the doctrine of abuse of rights under international law. And that doctrine says that any country that uses its rights not for the purposes for which it was intended will be violating international law. So now we move to discuss what are the justifications for the right to spy. And I put to you, if you look back at the sources that I put forward, that there's two justifications. One is a top-bottom approach. That's international stability, as you suggested earlier. The international community wants you to spy because we need it for our monitoring systems within the public order to ensure greater stability within the community. And one is a bottom-up approach. That's the national security position that was raised by the speaker before me. So those are the two and only two justifications for spying. And then we can start articulating things that will be abusive to the right because they don't serve this purpose. If Trump, as was suggested by a few reports, actually went about in establishing a private intelligence agency, which sole purpose is to spy on those people who are within the deep state, against Trump and against Trump towers and against his whatever. That kind of an activity would be a violation of international law because Trump in that context would be abusing his right to spy. It would be using the right to spy as a means to advancing a personal interest, not the national security interests of the state. Another example is using spying to advance an internationally wrongful act. If you tell your intelligence agencies, collect all the information about the Jews because we are part of a program which sole purpose eventually is genocide, the spying itself should be seen as a violation of international law because it is used as a means to commit an internationally wrongful act. And now we can begin articulating what possible wrongful acts might be. Think about annexation of a territory and spying in the preparation for such annexation. We might say that the spying itself might be unlawful. And the list goes on. The three other ones are far more controversial. But the last one is one Dr. Libicki writes about. He'll be speaking about it even tomorrow, I believe. And that's about spying as a means to advance corporate interests. That's industrial espionage. That's when I'm spying not to advance national security, but to advance my own corporation's competitive advantage against yours. Or you might think about Australia v. East Timor in the context of the spying scandal that happened there and the inclination of the ICJ to say, Australia, maybe you crossed lines there, maybe because that was a form of advancing post-colonial relations in the sense that Australia is trying to steal the only natural resource of a poorly developed post-colonial country. Maybe there we can draw a line. But we can begin sketching those lines. And that is a first step to a broader articulation of the Lex and I'll hand to here. Thank you very much.
Thank you, Asaf. I think what you proved is, in many ways, also that your position on how do you view as espionage in international law is to the age-old saying that where you stand depends on where you sit. Because I think even for some nations, they could say that it's not a liberty right, but also a claim right or a claim law, in the sense that they have to spy. And they are supposed to do it as well. But I think that's an argument that we could also go forward with. But if we looking at the norm and its perceived limits, I think little those mind experiments work as well, especially if you play the computer game Civilization by Sid Meier. And in the latest iterations, you can also train spies. And you might have, as a player, let's say an alliance or alliances with different nations. I would say that the first thing you do when you get the chance that you have developed the training of the spies, you will send them out with no qualms against your allies as well. So, and since human micro-interactions also reflect back into state interactions as well, and I think it's kind of in our nature as well as persons to have the best information that we have on our friends and our enemies as well. So in that sense, it is a bit of a Hobbesian world, this spying. But since everybody is doing it, it's a zero-sum game. everybody loses and everybody wins at the same time, and hopefully stability will come out of it. And I like the argument that if you really want to have proper self-defense under Article 51, you have to have the information. And that's why you gather that information and even provide intelligence if you do the analysis and all the cycles, etc. But we have talked a lot of how states view this field, what are different legal perspectives on it. But I think also Liis deserves at least a measured rebuttal of what to make of the Tallinn Manual after this.
Okay, so I have a lot of sympathy, actually, what both you and Janneke said, as well as Erkki implied it, which is that as rule of law countries, as Estonia, as Norway, it would be very uncomfortable to digest the idea that when you engage in some sort of espionage activities, as a state, you violate international law. If you're a rule of law country, it is a moral commitment to abide by international law and never to violate that law. But I think what we can't do is just simply wish away the reality that there are some rules in international law that states violate when they engage in espionage. And I mentioned diplomatic law already. I think this is the clearest example. When you look at the Vienna Convention on the Law of Treaties, it affords not only inviolability to diplomatic premises and the right to the standing state to use the diplomatic premises for the exercise of diplomatic functions, and covert spying is not one of them. And it also provides inviolability, which is a very broad protection, to all diplomatic communications. This is black letter rule. It's a part of a treaty that all states are parties to. And so from a very strict legal interpretation perspective, it is hard to come to a different conclusion other than when states do engage in espionage against diplomatic communications, they are violating international law. So this is something that we can't wish away. The sovereignty debate is somewhat more complicated, but even there we have some state practice. Also, you mentioned the U2 incident. I'm sure then you're familiar with how the legal debate went in 1960 when the U2 plane was shot down. There, the Soviet Union clearly treated the entry of the U2 reconnaissance aircraft into its airspace as a violation of its sovereignty because it was unauthorized presence of another state in the Soviet Union's airspace. That happened on 1 May. On 1 July, there was another aerial incident. It had to do with the RB-47 US reconnaissance aircraft. Now, that aircraft, the US claimed, was flying outside of the Soviet Union's airspace and was engaged in espionage operations, information gathering against the Soviet Union. And that plane was also shut down. Right. And there, the legal argumentation was quite different. The United States very forcefully maintained that that aircraft was outside of Soviet Union's airspace, and therefore it was not in breach of the Soviet Union's sovereignty, territorial integrity. So I think there is some opinion juris, there's some jurisprudence that we can rely upon to say that some operations, some espionage operations breach territorial integrity and therefore are unlawful. Also, actually in the Tallinn Manual, and this is also kind of a weird legal conclusion. Yes, we did come to the conclusion that when states spy in the territory of other states, that in most cases will be unlawful, but cyber espionage is not unlawful unless it causes those unintended consequences, because it is done remotely. And when you remotely penetrate systems in another state, we felt that it was stretching the law too far to say that a virtual presence in another state's systems should be equated to physical presence in another state's territory, like an aircraft in that territory. So I think we just can't wish away the reality that states sometimes violate international law when they engage in spying. The diplomatic law rule, to me, really is very convincing. And even when you read the authoritative commentary by Eileen Denza, leading expert on diplomatic law, she also says very clearly that this prohibition is, this rule is honored in the breach. Okay, so sometimes states do violate the law when they engage in espionage. The other thing that kind of caught my attention and what I got stuck on thinking was that even if you come to the conclusion, you take the view that espionage or cyber espionage does not violate international law, I am struggling to still understand why it would be morally more defensible for a state to then still send an agent to another state to engage in spying, knowing very well that that operative of the state, if it's a state organ, will be violating the domestic law of the state. So as a rule of law country, you would expect states not only to respect international law, but also the domestic laws of other states. So if you take international law off the table, a spy in another state engaging in covert activities against that territorial state will still be breaching its domestic law, which means that the spying is unlawful. So this is just something that I struggle to understand how it's morally more defensible to breach domestic law. So what does this leave us with? I think when we look at how states treat cyber espionage, the situation really is quite schizophrenic. Right? All states engage in espionage, and they hate it when other states engage in espionage against themselves. And what this leaves me with, and here I agree with Janneke, is I think that this debate is a very interesting one, especially for me as a legal scholar. But I don't think it actually has that much practical relevance. So, and here, yes, why we mentioned it in the Tallinn manual was that we could not address the elephant in the room, but ultimately, yes, states engage in espionage, they will continue to engage in espionage, and so either you take one view, it is not unlawful, they are acting in accordance with the law, fine, they will continue doing it, or they violate the law, but those violations will be tolerated, and those prohibitions will not be enforced the way that other violations of international law are enforced. And then this leads me to my final point that I'd like to make, which is that I think with regard to cyber espionage in particular, what we should be focusing on, and this was also echoed by all of you, I think, is really when does cyber espionage, if ever, tip the scale in terms of its social cost, viewed from the human rights perspective, what kind of limitations, if at all, should be placed on cyber espionage activities from the human rights perspective? When does its economic cost tip the scale? When do cyber espionage activities get so costly for states that they come together and agree that there should be some limitations? Again, we're seeing first steps here. We have the G20 affirming that states should not engage in economic espionage against other states for the purpose of providing a competitive advantage to their own companies or commercial sectors. And finally, when does cyber espionage tip the political scale? In other words, when will it become politically too costly for states to continue to engage in cyber espionage operations as they do today? When will it start undermining alliances to the extent that states come together and agree, okay, we will not engage in these particular types of espionage operations against each other? Or when will they just start getting so much external pressure from other states that will perhaps again force them to revise how widely they engage in those operations? So I think this really, from the international peace and security perspective, is really the key. Not whether international law permits or prohibits or gives states a right to engage in it, but rather, are there going to be some forces that will require states to put some limits on their espionage activities?
Janneke, Asaf, do you want to have comments?
Yeah, I can comment because my problem is that, I agree with you. It's an interesting academic discussion, what is international law and what's its relation with, when it breaches national law. It won't change a thing about how states operate. So perhaps it's better off to let, the creature, be silent and in the dark corners, perhaps. Because if you try to formulate this, and I accept your view that it's a violation of international law, for example, using diplomatic premises. I accept your view, but if I, as an advisor on this, my chief of defense meets me with the Tallinn manual and says, "But hey, all the legal experts says, are we breaching international law? As a lawyer, that would be really unsatisfying for me to say, yeah, you are, but just go ahead and do it anyway. So I'd rather, you don't address it if that's, if there's no lenience on how to move forward from this. Because I think, and I also very much agree with Asaf on all your, the reasons for and the legitimacy of intelligence as such. And it doesn't, get us a lot further on detailing international law. And I'm not sure we ever will. But I think it's, in my head, it's really easy to say that this is not, breaching, it's not a violation of international law, because it's an inheriting state right to do so. In order for us to actually protect all the privileges and our state's existence, we have to do this, and we won't stop. That's on the principle level, and then I think it's a difference on the discussion between it's the general principles on sovereignty, non-intervention, and so. According to espionage, and then its relationship with specific rights. And I think that's at least one area where we actually are able to move forward, and where I actually think that espionage and cyber espionage will see some legal limitation, which might also actually be expressed. And also in some of the cases going on and the discussion going on, the national cases and the international cases going on, states are forced to make some kind of official statements on how they see value, how far can you go when you conduct foreign intelligence and breaching, the right to privacy in order to protect your national security. That is being formulated, and I think that's, it's at least one place where we can move forward.
There's a couple of comments. One is, I think we need to change a disc in the way we conceive of this. It's not two camps. It's not, you're either in the myth system world, I'm going to use Michael Reisman's terminology, you're in the myth system world and you're just citing the Vienna Convention law of treaties and the UN Charter, or you're in the operational cold world where you're just saying everyone's doing it. That cannot be the way we articulate this space. We need to step outside of just saying those two things, which if you open those 3 books or 100 articles that have been written, that's what they say. Again, re-echoing those camps. We need to understand that we can think about a real lex specialis of espionage law that is a piecemeal account that recognizes that the law exists in the tension between the myth system and the operational code. And you don't have to adopt my worldview, but it is just a provocative alternative account. There's a lot of smart people in this room. You should write articles challenging these accounts, suggesting a different 4th account, 7th account. But how is it that we are bound to these conceptions? That's point 1. Point 2, and that is, I want to challenge a little this. There's a feeling on the panel right now that international human rights law, human rights will solve the problem. International human rights law cannot be where we put all our emphasis on, because international human rights law is equally challengeable by states, both in terms of its extraterritorial application, which we have written thousands of pages on, and states have different conceptualizations on to this day, and because even if you recognize extraterritorial application, in what cases, what types of remote cyber activity, and even if you do that, then you go to legality, proportionality, necessity. How do you apply these to particular foreign intelligence surveillance cases when you don't notify the subject that he's been spied on in a foreign intelligence context? There's also a big distinction between domestic surveillance and foreign surveillance, with different legal regimes applying to both. And so I don't think that we'll find our solution in human rights law. What I'm trying to suggest is that human rights law has failed us in resolving mass surveillance and foreign intelligence, and we need to think of general principles of international law as an alternative account to human rights law. And in fact, even Tallinn Manual 2.0 could not agree on proportionality as a customary standard in this context, and that's another big problem in the context of cyber espionage.
I think we're reflecting, let's say, in the general cyber law as well, this common frustration that we have, that we, as lawyers, we want to have norms. But at the same time, states create those norms as well. And at the moment, espionage has been around for many millennia, and we don't have really explicit norms that we can find. Let's say we can find them in law of armed conflict, of course, but other than that, not that much. But at the same time, in cyber law, we're grasping with the same thing, that we see a field that needs to be more regulated, more stable, and at the same time, those norms are not really forthcoming at this time. But actually, this debate can give a positive momentum to that, and that's why we need to have this as well. But we have addressed the elephant in the room many times. I think it's now time to address the audience as well, because they have to deserve their coffee break. So questions, answers? One there, second row.
Thank you. 3 brilliant talks. I'm really very impressed. My name is Kuba Mačák, senior lecturer in law at the University of Exeter. Thank you all. I have one question for our first 2 speakers and one for Asaf. So basically, the unspoken assumption on the panel was that when we talk about cyber espionage, we're talking about political espionage. Lisa, towards the very, very end, mentioned the G20 statement, and I would put it to you that there are others which also mention economic or industrial espionage as something where possibly the agreement in the international community may be more forthcoming than on issues of political espionage. So I was just wondering, our first 2 speakers, if you could explore, how deep the trenches are, and whether possibly this is something that you could agree on, whether these indications like the bilateral agreements between US and China are and others about economic espionage being impermissible in international affairs, whether these are indicating that some harmonious position is emerging, or maybe not. So I wonder what your thoughts are on that. Asaf, I'm going to push you a little bit on this derivative rights concept. So I wonder to what extent we can say, and maybe I misunderstood your position, I haven't read your paper, I'm not one of your reviewers. Yeah. But I think my question would be very similar to that they have all raised, because I feel very uneasy when I hear arguments such as, when we have a right, then whatever enables us the exercise of that right is a right in itself. So let me just take it on a very, very simple level, and you can say whether this parallel is useful or not. So in many domestic legal systems, we have the right to file for divorce in case of infidelity, on grounds of infidelity. But does that give us the right to explore all the information that might lead us to a finding of infidelity of our partner? Surely you would say no. So not everything that enables us the exercise of a right is, even in Hoffeldian terms, a liberty right, far less a claim right. So I wonder, what you would say to that. I'm much more sympathetic to the position that cyber espionage is an extra-legal affair, extra-legal matter, but to claim that it is a positive right that states have, I think you need more to justify that. Thank you.
Well, let's try to give it brief, but not just yes or no answers. But Asaf, can you just start with the last one and then address the first ones as well?
First of all, there's a lot more sources to international law than just the ones I cited, and some of them are far more clear than the ones I cited. There's treaty law that allows states to engage in intelligence gathering in counterterrorism context. The UN Security Council Chapter 7 resolutions that authorize states, they even say to them how they should engage in intelligence, from biometric data collection to communicating with tech companies. Okay, so the international community is not amorphous to this space, and to me, to suggest that therefore it's an extra legal construct is an it's just inconceivable with the fact that we have a lot of law in this space. So my articulation is just trying to explain the schizophrenia. And now you might not like, and again, you might not like my explanation, but the result cannot be, therefore, it's an extra legal construct. Now let me just briefly address why I think the liberty right claim works. What all that the international community has said is that we are willing to tolerate spying when it's done for the right purposes and using the right means, whatever those right purposes and right means are. In other words, we are willing to accept you entering my sovereignty, or willing to tolerate, and you've seen those being articulated, for example, in the Open Skies Treaty. So there's been even codification of these tolerations into treaty law. Okay, we're willing to tolerate you spying into my territory. But that doesn't negate the fact that if you do it clandestinely and I catch you, I can sue you. I can bring charges against you. I can kill you in certain circumstances. A liberty right just tries to explain this fact. How is it that I'm able to take actions against you, even if you have a quote-unquote right to do so. And in that sense, that is the sole connection I'm trying to solve there.
Maybe for the next CyCon proceedings, we can propose a panel on, let's say, espionage as an extramarital affair in international relations, to go with that analogy. Anyone want to tackle the first part of the economic part?
Yeah, and I would say yes and no. Or actually, to put value to it, no and yes. Because I think every time states do articulate some limitations, it helps on bringing us forward. So in that respect, yeah, it might be a difference between the political espionage and for economic reasons. Nevertheless, the purpose of and what I think legitimate espionage is it's for national security or international to keep international security. And that's the prerogative. What that is, it's the prerogative of each nation. So, whatever words to put that will ultimately always be the states who define what is related to national security, and if it's in order to have that information or to defend our national values, we will still do that. But as a matter of expressing some limitations officially, I think it has value.
Yeah, Kuba, so I think that particular norm that you referred to, the commitment of states not to engage in economic espionage, considering that the G20 has affirmed it, I think that's quite a powerful statement. The G20 is 80+% of the global GDP. However, states have been very careful to frame the economic espionage statement in political terms. And so I think what this tells us is that it's clearly not the law today, so it's not unlawful to engage in economic espionage. However, it might be the beginning of a crystallization of such a norm in international law.
Can I just say, because it occurred to me, I didn't address the marital thing. In my world, first of all, one needs to distinguish between domestic and international. But in my worldview, I don't see a problem. In fact, most domestic systems do allow certain forms of going to a certified private investigator to engage in some activities of surveillance of this kind. So I don't necessarily see a problem there.
Let's try to catch a couple of more questions in the break for coffee. To have something on this side. Going once. No, there.
Good afternoon. My name is Lloyd Beal from the United States Military Academy at West Point. My question basically is, at what point does espionage become an act of war? Does anybody know if there's a certain point that it could become an act of war? And if so, how do governments respond to that?
Any famous last words from panelists?
Okay, so espionage does not become an act of war. Actually, in law, we use it, I believe what you're referring to is an armed attack, which is the criterion precedent for a state to exercise its right of self-defense. And it's very difficult to come up with examples of situations where just plain information collection would rise to the level of an armed attack such the victim state can exercise its right of self-defense. I can't actually give you any examples right now.
I just want to say that Cicero once said in a different context on laws of armed conflict that those, when the cannons roar, the muses are silent. And we proved them wrong when we created the Hague Regulation, Geneva Convention, addition protocols. We now say that when the spies connive, the muses are silent. It didn't make sense in Cicero's time. It should not make sense in 2018.
And I also can, address that. Going from, what is the purpose of espionage is information gathering. If you're, either you have really, really lousy intelligence service who doesn't know what it's doing, if it amounts to such a use of force that it's actually an armed attack, so it's an act of war. Otherwise, it's just not espionage.
I think this is something that Tallinn Manual also addresses, that if you go too far with the means that you're procuring this intelligence or information, that if you go overboard with the means and violate international law, as well as creating the fact of either an armed attack or a use of force, well, well, the joke's on you because you're doing a really bad job in intelligence gathering as well. So you shouldn't with those means, actually ever elevate into that sphere as well. But I think there is a certain nuance in this discussion as well of how well do you know your opponent and what are their thresholds as well of pain and allowance for you to spy. Because they might construe something that might not be legally as an act of war, but they might find a pretext for politically in that sense. But that's this legal policy game that we have. But I want to thank the panelists taking the time to challenge this very intellectually difficult topic and coming out alive from it. And you can now go back to spying on each other on Facebook or Twitter or Snapchat, wherever you do that. But share the info on Signal, I'd prefer. But at the same time, I think we also saw that this is a law of collective or mutual frustration. And maybe next year we will have better answers for the audience as well. So let's thank the panelists.